पे. So section number 26 and section number 27 of Indian Contract Act are to be covered in this video. Basically, section number 23 and 24 we have covered in the last two videos. About consideration we have earlier talked in one of our videos. So today we are talking about the specific contracts which are declared to be void under Indian Contract Act. So section number 26 talks about a contract of restraint of marriage, and section number 27 talks about restraint of trade. And both of these, when we talk about these contracts, we'll discuss what are the different situations which arise in them, what are the exceptions to them, and what are the different case laws which will help us to understand the situations more thoroughly. Okay, so let's start the video. If we talk about contracts about restraint of a marriage, so any contract in the Indian society which is in restraint of marriage is void other than that of minors. This is mentioned by section number 26. So let me give you an example, a very good example of LOWE versus PSO case. In this case, what happens is a man is forced to make a contract. A man has made a contract with a woman that he will marry her only. Okay. Now afterwards, the contract has one more clause that if he doesn't complete this marriage, then he has to pay some 2,000 rupees to this particular woman. So being the nature of this contract in a restraint of marriage, like this contract is forcing this man to get a restraint to this particular woman and not being able to marry according to his will. So this contract is void in nature. Okay. And this consideration and anything whatever is decided in this contract was of no value if we talk about restraint of marriage. Okay, so when we talk about restraint, it's not necessary that it is a total restraint only. Like, it is not necessary that you are forced to marry a particular person forever, or you are forced to not marry anyone forever. It is not necessary. Even if you are forced to do such thing for a small period of time or from a certain group of people, like if you are forced to marry a person from these 10 people, okay, so this is also a restraint of marriage. And if you are forced not to marry for the next 4 years, otherwise this thing will happen, this is also restraint of marriage. Now talking about one more example, in this case of Lafatunisa versus Saharbanu, in this what happened was, actually when we talk about remarriage, then there is a different case. Like if a woman has an agreement that if she'll marry or she'll remarry, then she will lose the authority in the estate of her previous husband. This contract by its nature is not in restraint of marriage. This was declared by this case, Lafatunisa case. Okay, so when we talk about restraint of marriage, only this much is there which you need to keep in mind, because it's a very small section, very easy section. These two case laws with this much of information will be enough for you. Moving on to our next topic, restraint of trade, that is contracts or agreements in restraint of trade are void agreements. Yeah. Listen, under Article 19 of Indian Constitution, we are given the freedom to profess any career, profession, anything, any trade, business, anything of our own choice. Now, if we are not allowed to do so, then there is something in contrary to it. Yeah. So section 27 says to us, when anyone by an agreement is restrained from performing his lawful profession, trade, business, etc., then it is void in nature. Void to the extent. Yeah, means if supposingly I am not allowed to carry on my business for next 2 years. Okay, so in this case, although the restraint is not permanent, but if I am restrained to that extent also, it is also void. That is what is said meant by this word, to the extent. Okay. Now, if I talk about a very good case law, which will tell you about two situations, that is Nordenfeld versus Maxim Norden Guns and Ammunition Corporation Limited. Also, in this case, what happened was there was this company of gunpowder production, which was of Nordenfeld. Okay, so what happens is he makes an agreement with this other company, Maxim Nordenfeld Guns, that with the amount of 2,87,000 something rupees, or with something rupees, the agreement was made such that he will not produce any kind of guns in the future for the next 25 years in the locality in which this company is functioning. First point. Also, the second clause of this agreement mentions that he will not do any other kind of business which will be in competition or will give hindrance to this. Now, court said that when we talk about restraint of trade, then one point is to be kept in mind, that it should not be unreasonable, and if it is for the benefit of the parties, then it can be allowed. So what happens is, here a huge amount of money was given by the buyer of the business of guns to the seller, okay, to the Nordenfeld. So it was said the first clause which prohibited Nordenfeld to establish a similar kind of business which was of production of gunpowder only was considered to be a valid clause, but prohibiting himself from establishing any other kind of business was not a good choice, was not a valid point. So it is said that we need to decide what is good for the people who are getting into the agreement. Cool? And if it is not hindering the interest of the parties, then it can be allowed. Cool? So this is about English law. Now what happens in the Indian condition is Madhav Chandar versus Raj Kumar. So in this case what happens is, two people are there, A and B. They are in a similar kind of business. One of them agrees with the other that I'll sell you my business and will not carry out this particular business in this particular locality for some particular time. Now what happens is, this was a partial restraint on the business of the other. So then also it was declared to be a void agreement. It was declared to be in a restraint of trade, which was in the Indian context. Now what we derive from this? Listen, when we talk about English sense, now we see whether the agreement which is done is for the good of the parties, or is in good faith, or is not is not to establish any monopoly, or is not having any malified means behind it. But when we talk about Indian context, the case is much more stricter. That is, if the 5 exceptions which I am going to discuss with you just now are not fulfilled, then automatically any agreement, any such agreement, even partial or full, will be declared void. Clear ho raha hai? Now next point is the exceptions. Yeah, whatever I have just mentioned about the Indian context, or about this even section of section 20 of Indian Contract Act, that is section 27, we have some exceptions to it. Yeah, so let's find out what are they. First is sale of goodwill. When we say that if a business has sold his goodwill, yani ki in the market any particular business maintains a goodwill about it, that kind of business is good in selling of particular kind of product. Okay, now if he comes in contact with a buyer and sells his business to him, okay, then a contract with the buyer to not establish a similar kind of business is not void, because it comes into an exception of this kind of agreement. Yani ki what happens there? Here we are trying to protect the interest of the buyer, because a person who has sold his business of the similar kind, if he starts it somewhere else in the same locality, then it will ultimately hamper the interest of the buyer who has given such a large amount for buying that business. Although the point to be kept in mind is, when we are talking about this selling of business then it should not be to remove the competition from the market. It should be there to protect the buyer's interest only. That is the point which has to be clear, which has to be seen in every particular case. Okay, so what happens in this case of Vancouver Malt versus and Sake Brewing Corporation versus Vancouver Breweries Limited? So here, what our seller of the business was having this license of producing liquor and in the particular locality. Okay, so what happens is when they sell the business, they sell the goodwill of the business, and they actually have never produced liquor. Instead, they were producing this particular Japanese liquor called Sake. So what was said by the court is, if they have never produced liquor, they actually have no goodwill about production of liquor in the market. So there is no question of sale of goodwill in this question. Also, when this contract was made, there was also a clause that they will be allowed to sell this Sake, what they were producing earlier, but they will not be allowed to set up any other business. So that was something something which was of a very wide horizon and which is said to be an unreasonable clause, unreasonable restriction. So that is why it was said that it is still void because of these two reasons. Although it was claimed that there was a sale of goodwill. Cool? Now, moving on to our second clause, that is some clauses of Indian Partnership Act are also exception to it. Yeah, we have 4 clauses, that is 11 clause 2, 36 clause 2, 54 and 55 clause 3. Yeah, so let's talk about each of them one by one. What happens as per 11 clause 2 is, when we are a partner in a firm, then if an agreement is coming into existence between each of us, then we are not going to establish a similar kind of business as a competitive business in the particular locality in that particular time when our partnership is running, then that is not against this section 27 and it will not be it will be a valid agreement. Okay. Second is 36 clause 2. When an outgoing partner, yani ki when a partner resigns or when a partner has left the firm, then it can be like he can make an agreement or he can be made to make an agreement so that he will not establish a similar kind of business in competition with the particular business, so that it will not hamper the interest of that particular partnership. That agreement will be considered as a valid agreement only, and there will be no such thing which will make it void. Second point. Third point is 54th, yani ki during the dissolution of a firm, all the partners can be made, like when the firm gets dissolved, supposedly when a firm gets dissolved and it is made to sell to a particular third person. So all the partners can be also asked or also made to make an agreement that they will not establish a similar kind of business, and that will also be a valid agreement. Clear? Fourth is 55 clause 3, sale of goodwill. When a business is sold by the partners to a third party, similar point in one or the other way. Okay, you may understand it. Okay, when we talk about our third point, that is restraint by constraint of service. That is, in current scenario also, let's see, when some companies are there which are making a contract with their employees that you will work for a particular period of 1 year with us. Okay, now if we are saying about this kind of constraint of service, so what happens in this case of Charlesworth versus McDonald's is, there was a doctor, he has an assistant who has contracted with him to practice with him for the next 3 years. Now what happens is, after 1 year he establishes his own practice. What the doctor sues him for is to restrain this practice, and the court grants the restraint because of this because this is not against section 27 and this agreement is a valid agreement. Clear ho raha hai? Next is our fourth clause, that is a solus agreement. Solus agreement was, it means that if I am producing some good, then I will sell it to a particular person only. That kind of agreement is solus agreement. If that is not to establish monopoly and is to for the benefit of the buyer and the seller only, then it can be a valid agreement. Like supposingly in case of Mackenzie versus Istria Ramia, what happened was the seller was producing salt, and it was claimed by the buyer that he will buy all the salt produced by him and he won't sell this to anyone else. So this was not against this section 27, and this agreement was considered to be a valid agreement. Now here are two exceptions to it. Exception KB exception hai, yeah, there are two exceptions to it. That is, first is if the buyer is not buying all the quantity produced by the seller, then he can sell it to someone else, and an agreement for not selling that amount of good which is produced by the buyer and seller and not bought by the buyer is not valid agreement. Okay, and when we talk about the second clause, then it should not be to monopolize the trade, and if it is to monopolize the trade and reduce the competition or anything like that which is having a malified intention, then it would not be coming under this. Okay, so if it is for the interest of the buyers and the sellers only, then it will be a valid one. Clear ho raha hai? Last point, last exception is trade combinations. Yeah, sometimes what happens is to reduce the competition between the producers of a similar kind of product, what people do is they form associations, they form combinations, so that they will fix a particular rate and they all will sell their products in the market without any competition between them. So that happens in a trade combination. So this kind of agreement is also not considered to be void and is also not considered to be against this section 27, because here also what happens is it is for the benefit of the sellers and for the benefit of the buyers. They are not doing anything against the public policy. Now the case law of this is English hop growers versus Daring. Here what happens is an association of hop growing companies come together, and now one of the members of the association supplies the good to the association so that it can be sold in the market. Now the point is the person or the association member is forced or is not allowed to sell his products individually, but has to sell it through the association only. Now this kind of restraint on the member of the association is not considered to be a void restraint. It is considered to be a valid one just because we are saying that this is an exception to section number 27, and so it will be a valid agreement. Is it clear? Are all the 5 exceptions clear? Are we clear with the section number 27? And if not, then do ask me in the comment section. And if you like the video, kindly subscribe to the channel, and yeah, enjoy.